Even though you used improper redactions to protect Donald Trump and other predators associated with Jeffrey Epstein, you did the exact opposite thing with the survivors and victims of this scheme. So their identification information was really the only thing required to be redacted, and it was not. And it's clear this was not a mistake. This was not by accident. This was not because you only had 30 days when you really used 75, and that doesn't even include all the hours last March that you were redacting it. But I'll tell you why it's clear it wasn't a mistake. There is an email entitled Epstein Victim List. There are 32 names. 1 is redacted, 31 are not. So someone looked at it and decided to redact something. And I will tell you that that is clearly intentional to intimidate these survivors and victims.
Welcome to the courtroom of American democracy. Today's case is not about one man. It is not even about one crime. It is about whether the United States Department of Justice, the institution designed to protect victims, instead protected the powerful. At the center of this case, unredacted files, hidden evidence, and the shadow of Jeffrey Epstein.
The central allegation is clear and severe. Did federal officials deliberately redact documents to shield politically connected individuals while exposing the identities of victims? Members of Congress demanded transparency. Instead, they claim they received obstruction. This is not a policy disagreement. This is an accusation of institutional misconduct.
And I am looking forward to your detailed explanation for why you have withheld almost half of the documents, which is required by the bill. Now, obviously, there are 3 million documents, so I didn't get through much. But one thing I didn't see was the client list that you said you had on your desk a year ago. I did, however, find a couple of important documents. An 86-page prosecution memo from the Southern District of New York, and a draft indictment from Florida against Jeffrey Epstein's co-conspirators. For reasons that I cannot understand nor are permitted by the bill, they were still redacted, even for members of Congress. So, Ms. Bondi, will you commit right here to immediately providing those 2 documents in unredacted form to members of Congress?
Let us examine the evidence. Congress had statutory authority to review the Epstein files, yet according to this testimony, nearly half of the documents were withheld. 2 specific pieces of evidence were redacted: a federal prosecution memo, a draft indictment against Epstein's co-conspirators. These are not peripheral records. They are the blueprint of the criminal case itself. The implication is explosive. Congress was denied access to the very documents that explain who was investigated and why. Here is how the process was supposed to work. Congress passed a bill mandating disclosure. The Department of Justice was required to provide the files. Sensitive victim information was to be protected through redaction. Everything else was to be released. But according to the accusation, the process was inverted. Evidence about powerful individuals was hidden. Identifying details of victims were left exposed. This is not merely a bureaucratic error. If true, it represents a reversal of the legal duty to protect the vulnerable.
Now, would the survivors and victims who are here please stand up one more time? Just by show of hands, how many of you or your loved ones actually have met with the Department of Justice and provided testimony and estimate and evidence? None. And of those of you who have not met, which is everyone, how many of you have reached out either individually or through a lawyer or representative to offer to provide testimony and evidence? All of them. And of those of you, all of you, who have reached out, how many of you were denied or ignored by the Department of Justice? All of them.
This is the moment the case stops being abstract. Real victims were in the room. They raised their hands. Not one of them had been interviewed by the Department of Justice. Yet every one of them had attempted to provide testimony. In a criminal investigation, particularly one involving trafficking, Victim testimony is often the cornerstone of prosecution. Ignoring that testimony is not a procedural oversight. It is a collapse of investigative duty.
I also found an email that I have right here from Jeffrey Epstein to Ghislaine Maxwell that was unredacted, and it included notes of statements that Donald Trump made about his prior relationship with Jeffrey Epstein. Now, there is no reason for this to be hidden from the American people. There is no privilege, there is no attorney-client privilege, and I see you're checking with your staff, and I can assure you, staff, this is not under attorney-client privilege because it was sent from Jeffrey Epstein to Ghislaine Maxwell. Will you commit to publicly providing the unredacted version of this so that the American people can understand the extent of Donald Trump's lies about his relationship with Jeffrey Epstein?
Power leaves fingerprints. The clip introduces a critical document, an email chain allegedly referencing statements made by Donald Trump about his relationship with Epstein. This is where the stakes escalate from bureaucratic dispute to political consequence. If such material was withheld improperly, it would not merely be a document control issue. It would suggest selective transparency, a form of institutional shielding. The defense presented during the hearing rests on a single word: privileged. Officials argued that certain documents could not be released because they were protected under legal privilege, including attorney-client protections and investigative confidentiality. They also implied that critics were politically motivated, suggesting the questioning was driven by prior partisan disputes. In legal terms, the defense is asserting lawful redaction and procedural discretion. But the prosecution, in this case congressional investigators, dismantled that defense in real time. They argued, emails between Epstein and Ghislaine Maxwell are not protected by attorney-client privilege. Congressional statute overrides discretionary withholding. Redactions were applied selectively, shielding the powerful while exposing victims. In other words, the defense relies on privilege. The evidence suggests selective application of that privilege. And selective application of law is itself a violation of equal protection principles. To understand the gravity of this dispute, we must clarify the legal mechanisms involved. Redaction is the removal of sensitive information from documents before public release. It is lawful, but only when used to protect ongoing investigations, classified material, or victim identities. Congress, however, holds oversight authority. When a statute mandates disclosure, the executive branch must comply unless a recognized privilege clearly applies. Improper redaction can constitute obstruction of congressional oversight, or failure to comply with statutory disclosure requirements. In extreme cases, it can trigger contempt proceedings. This case reveals potential breakdowns across multiple institutions. The Department of Justice, accused of ignoring victim testimony and withholding documents. Congress, forced to rely on adversarial hearings to obtain evidence it was legally entitled to. The broader accountability system, which failed to produce clarity years after Epstein's death. Institutions are designed to check one another, but when each branch accuses the other of misconduct, the result is paralysis, and victims remain without answers. Let us summarize the record. Congress demanded unredacted Epstein documents. Key materials remained withheld. Victims attempted to testify and were ignored. Officials justified secrecy using privilege claims that are legally contested. The forensic record does not prove a criminal conspiracy, but it does establish something deeply troubling: a pattern of secrecy applied in ways that appear to protect the powerful and expose the powerless. The Epstein scandal was never only about one man. It was about the network around him and the institutions that failed to stop him. Now, years later, the question is no longer who enabled Epstein. The question is whether the justice system itself concealed the truth. The files were redacted, the victims were ignored, and the public was told to trust the process. The prosecution rests.